3-judge panel happened to say effectively, well, this case is going to be decided by another 3-judge panel late February. Yeah, so your constitutional rights are completely abrogated for 60 days. What's the big deal? Hi guys, this is Steven Lieberman. You've seen most of my videos, I suspect, probably from my office. This one is kind of an emergency, and it's specifically to everyone in California. As you know, we've been talking about a California law called SB2 for quite some time. Back in September, Gavin Newsom signed this bill into law that is massively unconstitutional, okay? I don't say that from a normative standpoint. This is just frickin' empirical, okay? One of the components of SB2 has to deal with what we call sensitive locations. These are basically everywhere within the state of California. Their argument essentially is, look, we have to give you a CCW. We sort of acknowledge that, but we're going to turn all of the state into a sensitive location, certainly anywhere where people congregate, okay? This type of bill, this type of law has been challenged numerous times across the entire country. Interestingly, within the Ninth Circuit itself, Hawaii tried doing something like this, and the Ninth Circuit told them no, all right? So Judge Carney, back about a week ago, issued a preliminary injunction preventing the sensitive location components of SB2 from going into effect. Now, of course, the state immediately appealed, and a lot of people were asking me, do I believe that the state is going to win on appeal, overturning Judge Carney? And I said then, and I will say again now, no, I don't believe that the state is going to prevail on their ultimate challenge to this preliminary injunction. Keep in mind, we're not talking about the underlying case. We're just talking about the preliminary injunction. Well, one of the things that they asked for in their appeal of the preliminary injunction is an immediate stay, all right, effectively saying, hey, listen, while this interlocutory appeal is being litigated at the Ninth Circuit, we want the law to go into effect. There is no logical reason for this to be granted, but that's exactly what the Ninth Circuit just did. Effectively, they have said, and they didn't say it in their decision, their order is a page and a half long, and it says nothing about the merits of the case. A 3-judge panel happened to say effectively, well, this case is going to be decided by another 3-judge panel late February. Yeah, so your constitutional rights are completely abrogated for 60 days. What's the big deal? That effectively is what they've done. It is pure tyranny, and it should not stand. That being said, that's exactly what has happened, and as a result of that, this is critically important. If you live in California and you have a concealed weapons permit, at least starting on January 1 and going till probably around the end of February, if you are in one of the sensitive locations with your firearm, and arguably speaking, 99% of California is, then you could potentially be arrested and prosecuted, okay? Now, it'll be interesting to see whether or not locally elected sheriffs actually uphold some of these sensitive locations. That's something else that we'll have to see. But nonetheless, at least for the time being, while this preliminary injunction is being litigated, it's back into effect. I am unbelievably infuriated right now, but it's important to get this information out as quickly as possible so that nobody that doesn't want to run afoul of the law does. In any event, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.
Before you go, you just missed one of our best videos that got over 500,000 views. Click right here to watch it now.